for live streaming. Good afternoon. Welcome to the Joint Standing Committee on Labor and Housing. I'm Craig Hickman, representing Senate District 14, 11 towns in Kennebec County, including my hometown of Winthrop. Since this is a new session for the afternoon, it's a public hearing, we'll be taking up LD 1711. I'm going to ask committee members to introduce themselves once again for the public who may only be here for this and only this. Representative Drinkwater.
Wow, I didn't expect to be called on first, Mr. Chair. Good afternoon, Zoom land out there, wherever you are. I'm Representative Gary Drinkwater, House District 121.
Representative Pebworth.
Thank you. Good afternoon. I'm Sarah Pebworth. I represent House District 133, which includes Blue Hill, Brooksville, Brooklyn, Castine, Sedgwick, and Surrey.
Representative Rader.
Hi, my name is Amy Rader. I represent House District 125, which is a portion of Bangor.
Representative Morris.
Good afternoon. I'm Representative Joshua Morris, represent House District 75, which is Turner, Leeds, and Liverpool.
Senator Gary.
Good afternoon. I'm Senator Stacey Guerin, representing Southern Penobscot County.
Representative Cuddy.
Good afternoon. My name is Scott Cuddy. I represent House District 98, which is Winterport, Frankfort, Searsport, and Swanville, and I live in Winterport.
Representative Bradstreet.
Thank you, Mr. Chair. I'm Representative Dick Bradstreet from House District 80, and that's made up of Vassalboro, Windsor, Somerville, and part of Augusta.
Representative Warren.
Good afternoon. I'm Sophie Warren, and I represent my hometown here in Scarborough Coastal District 29.
And we have with us today Mr. Langland, our analyst, and Ms. Alyssa Thompson, our committee clerk. Today is her last day with us. And so give her a round of applause every opportunity that you can, since she has been keeping us on track and working out all of our technical difficulties and making sure that you all get the links that you need. This is a special committee in many ways. One of them has a separate work session link, and she's the one who manages all of that. So, thank you. Senator Miramont, introduce yourself.
Oh, yes, thank you. Dave Miramont, representing Senate District 12, Knox County, and the county seat is Rockland. Thank you.
You're welcome. And so I don't, committee members, we will have them introduce themselves as they arrive. With that, I do believe that President of the room. We open up the public hearing on LD 11. Everyone can mute their microphones. I hear mute. Thank you so much, everyone. I will open up the public hearing on LD 1711, an act to enhance enforcement of employment laws, presented by President Troy Jackson of Aroostook. Welcome, Mr. President.
Well, thank you, Senator Hickman and Representative Sylvester and members of the Joint Standing Committee on Labor and Housing. My name is Troy Jackson. I represent the fine people in Northern Aroostook County in Senate District 1, and I'm here today to present LD 1711, an act to enhance enforcement of employment laws. I believe wholeheartedly that all Mainers deserve a safe work environment free from harassment, abuse, and discrimination. They should be able to speak out and take action when they experience or witness any wrongdoing. However, too many Mainers have signed away their ability to speak out the minute they sign an employment contract. LD 1711 seeks to protect and support the safety and security of Maine workers who are brave enough to speak out and report wrongdoing in the workplace. Whether it's a violation of employment law or human rights law, Maine workers should be able to speak out and demand justice. And the current law is failing them. This proposal would allow a whistleblower to work with the public agencies such as the Attorney General's Office, the Maine Department of Labor, and the Maine Human Rights Commission to bring a private enforcement action for a workplace violation. Although Maine has a Whistleblowers Protection Act and anti-discrimination and wage and hour laws on the books, their reach is limited and they can be hard to enforce. This is certainly something that I've seen all my life in the logging industry. And despite these laws, too many Maine workers still face wage theft, misclassification, health and safety violations, sexual harassment or discrimination in the workplace, overtime violations, and more. In order to be protected under the Whistleblowers Act, the employee must first report the wrongdoing to the employer. Due to the imbalance of power, this requirement is very problematic. Additionally, the scarce number of investigators working in the Department of Labor cannot adequately cover the number of businesses in Maine. Currently, there are only 5 labor and safety inspectors in the entire state, although the department plans on adding another in the coming fiscal year. These inspectors, according to the 2020 annual wage, oversaw 55,331 employers and 584,143 employees. The numbers look even bleaker for 2021 because the March estimate put monthly payroll jobs back up to 609,600. Obviously, the resources need to ensure worker protections like minimum wage, earned sick and family leave, work week standards, and protections against discrimination and harassment cannot be met with limited resources. Another imbalance of power is the growth of forced arbitration clauses in employment contracts. Many of these clauses are buried in the fine print, are difficult to comprehend, and are required in order to get a job. Such agreements limit employees' legal rights and muffle corporate accountability because there is no public record. One way that we can protect our workers and those employers who follow the rules is to enact policies like the private enforcement action outlined in this bill. If enacted, one of the bonuses is that a percentage of the penalties from a successful action will be deposited in the Community Outreach and Labor Education Fund. This non-lapsing fund will be administered by the Department of Labor and will assist workers enforcing employment rights by providing training materials and technical assistance, counseling, investigative research, and referral services. Now, I realize this is a complicated proposal, and those of you who were here on the Labor Housing Committee last session will likely remember the amount of work stakeholders committed to put this bill in its current form. It's based on a successful model of California's Private Attorney General Act, which has been in existence since 2004. It's a model that will enhance the enforcement of workplace violations that hurt both workers and employers in the state, such as the fraudulent misclassification as employees and as independent contractors, which is a huge issue. By protecting those who take the risk of reporting workplace misdeeds, the integrity of our economic structure is protected as well. For these reasons, I'd ask that you join supporting 1711. And I want to be very clear that by far the vast majority of employers are doing great work. But the inability of the state to enforce existing laws definitely lets bad actors, taint the whole crew, and that's unfortunate because I know many employers. I've worked for very many employers that I have the utmost respect for, but at the same time, I don't think it's fair for government inaction to allow some people to run amok. So again, I'll thank you for your time. Great work that you do. This committee, I know, has a lot of bills, has had a lot of work. I know it's been a long run, and I really appreciate everything you do, even when you vote against me. I appreciate it. And I'll take any answers, and confident that there are others that will testify on the bill who are better at talking about the legal aspects, but I'll certainly try my best.
Thank you. Thank you, President Jackson, for presenting this bill and for your testimony this afternoon. And we don't mind that you dump this on us on a Friday, our last day of work. It's really okay, because you know what? We got this.
All right, no comment.
Representative Cuddy.
Thank you, Senator. Thank you, President Jackson, for the bill. And I wanted to ask quickly, would this be the kind of thing, I had a constituent at one point who had suffered from wage theft, had not been paid overtime when he should have been, and there was an extraordinarily long case, I guess, with the Maine Department of Labor, and he wound up really not getting what he was due. A case like that of wage theft, is this the kind of thing where he could have possibly used this law? Does that sound like to you?
Yeah, Representative Cuddy, I mean, like I said, the whole intent for obviously the bill is that, the state, obviously legislature enacts laws that are designed to protect employers and employees. And when the agencies that are in charge of that aren't able to enforce them, either because of lack of resources or just don't have the staff, then I believe that a bill like this, what we saw with the California model, allows people to go through a long process, and at least go and see if they can get an action taken to get the dispute resolved. And so wage theft would definitely be one of the issues that somebody could bring forward if the department chose not to, for because they don't have the resources. I know that people will argue that frivolous lawsuits will be rampant because of this. I completely disagree. I think that frivolous lawsuits happen, and that's unfortunate. But lawyers that bring these cases that maybe in some people's mind frivolous, that won't last very long, if at all, before it gets completely rejected. What we have is a case of this Department of Labor being lessened over the years and not having the resources. I mean, I don't think of myself as anything extraordinary, but I'm Senate President here in Maine. And when I can't get a government agency to look at some of the issues that I brought forward, then I would imagine it's very hard for someone that has no connection to any of these agencies. And that certainly has happened to me numerous times. And I guess the department will be in opposition to this bill because there's 2 people being added. That doesn't give me any faith that it's going to, obviously, will cut down a little bit on the amount of people in the agency compared to the amount of workers out there. But that's not enough still. That's nowhere near enough. So anyways, thank you, Representative Cuddy.
Thank you for the response. I appreciate it, President Jackson.
Chair recognizes Representative Bradstreet.
Hey, Mr. Chair, good to see you, Senator.
Same here.
Yeah, I'm looking at the summary, which is what I normally do. And it says something about if the state declines to intervene in a case. Now, do you see a difference between the state agency having looked at the particular situation and judged that there's no merit to the claim, or that they just don't want to proceed with it because they don't think it's a major enough claim, or they're just not short-handed?
Yeah, I mean, obviously saying that there's no merit to a claim, I mean, still, I think doesn't completely torpedo a claim, but it certainly adds a lot for any legitimate lawyer, and certainly any lawyer that brings forward a case that the state has said that there's no merit is going to have an extremely high bar to get across to a court or a judge. So I do think that, again, will be helpful in weeding out frivolous cases, which I have no desire to have. Understand that there could be some, but I just want to be clear that because the department says there's no merit, wouldn't totally throw out a case, because, I mean, I don't always think that departments are always willing to go forward with issues, but certainly when they say they don't have the resources, which I have had, told to me, then I think it definitely at that point, that is an open issue of the people that have been aggrieved should still have an opportunity, and right now they don't. I mean, there's really nothing you can do at this point the state says, well, we just don't have the resources to pursue this.
Follow up, Mr. Chair.
You may proceed.
Thank you. So you're basically stating that if indeed they do find there's merit, you're not satisfied with the remedy that the state currently possesses.
What I'm not satisfied with is the amount of times that people have brought forward something that the state says that they don't have the resources to pursue. I don't believe that's a legitimate excuse. I don't think anyone should be given that excuse that we just can't look into this. Now, if the state says that they have looked into it and there's no merit and legitimately done that, then that's a different issue. Like I said, I wouldn't throw those out of there because obviously people could just consistently say, well, we did look at it, there's no merit. And that wouldn't be fair either. But when you say that, we just don't have the resources, I don't agree with that. I mean, you should have the resources. Laws are on the book and they're intended to be followed. And I can't tell you how much I believe that when some people don't follow laws, that's really unfair to good employers that are following good laws and are following the law and trying to do the best they can in their business.
Are you satisfied, Representative Bradstreet, with the answer to the questions?
Yes, I am. Thank you.
Thank you. Are there any other questions for President Jackson at this time? Seeing none. And with that, we will move to public testimony from the public. But first, Chairman Sylvester, are you here to introduce yourself once more and to run the clock, or are you run the clock because because it's a busy Friday there on the island?
I am one of my workers injured himself, so I am both working and helping him. And so, I am Representative Mike Sylvester. I represent District 39, which is a part of Portland.
Great, thank you. And so who on our committee today is going to keep the clock for our testifiers so that they all know that 3 minutes is about what we ask for, or less than 3 minutes? Representative Cuddy will be holding up his cell phone to give you a 30-second warning toward the end of your testimony. So if you are here to present testimony, please put your Zoom on gallery view so that you can see him when he raises the warning. There it is, 30 seconds away from the conclusion of the 3 minutes is when that goes up. Folks here have probably testified before, but please do not turn on your mics or your videos until you are asked to present your testimony by the chair. We appreciate that very much. When you come through the wormhole, it could take a bit and you may think you've lost connection, but you will rejoin us momentarily, so just be patient with that. We tend to promote people 2 or 3 at a time so that we can have a smooth flow of testimony. So with that, we have 16 people signed up to testify in favor of LD 1711, and we'll hear that testimony first, and then we'll turn to testimony opposed. We have 2 people signed up for that, and then we'll go to testimony neither for nor against, where we have 1 person signed up for that. So we'll begin with Carrie Walsh, followed by Bernd Erickson. If I pronounced it incorrectly, please tell me so. And Roxanne Kai Petrovich, same thing. So I shouldn't say Mr. Carrie Walsh. You are first. There you are. Good afternoon. Please turn on your mic and present your 3-minute testimony to us today.
Hi. Senator Hickman, Representative Sylvester, and members of the Labor and Housing Committee. My name is Carrie Walsh. I'm a resident of Topsom, and I'm here today to testify in favor of LD 1711. You know those plastic clip strips in grocery stores, the ones that usually have small items on them like straws or magnets? Just over a year ago, I was working for a company that was responsible for the ordering, stocking, and management of these items, Adjacent Merchandising. I was the area manager responsible for parts of Maine. The items we were providing were already available in the stores. The only difference was that theirs would be found on shelves instead of on the plastic clips we restocked. Many of the people I was working with were retirees or other high-risk individuals. They were trying to make some extra cash to cover essentials. Jason didn't provide masks or gloves, but were still requiring that we go inside of very crowded, hectic areas. I didn't think that the work we were doing should fall under the umbrella of essential work, and I attempted to say so to my direct supervisor. The message I got back was that workers didn't have to do the work, but then they wouldn't make any money. Some of my former coworkers expressed issues they had with getting unemployment benefits approved, as the company tended to dispute unemployment claims. The work we were doing was an obvious potential spread for COVID. Our workers were going in and out of grocery stores across New England, coming in contact with many different people. Since I was getting nowhere with my direct supervisors, I decided to try another tactic. I sent an all-staff email to everyone, including the CEO, to discuss my concerns. Within minutes, I was completely locked out of the system and was essentially fired. I couldn't even file for my last paycheck. Nobody responded to me, they just ignored my messages. I did hear from dozens of employees who were scared of speaking out or doing something. Many of them were working paycheck to paycheck and were scared of taking any action themselves. I started to move through the legal system to take action. A few months ago, as I was moving through the steps, I was sent a copy of an arbitration agreement that I had unknowingly signed. When I was first hired, I was sent a large virtual document through DocuSign and had to sign every document in order to work. So I didn't really have a choice. I was told that because I had signed this arbitration agreement, I could not sue. I was also told that because it had been over a year since I was fired, I could not use arbitration. So where does this leave me? I strongly urge this committee to support LD 1711. We need to hold law-breaking companies accountable and protect workers. The fact that I've heard from dozens of workers experiencing issues is so telling. The ability to blow the whistle can expose company-wide violations that may go unchecked otherwise. Thank you.
Thank you for your testimony, for being here today. Are there any questions from the committee for Carrie Walsh? Seeing none. I take that back. The chair recognizes Representative Warren.
Thank you very much for your testimony. It sounds to me like you did a incredibly brave thing for the people that you work with, and it seems to me that it should be honored and recognized as such. At least I feel it may ought to be. I'm wondering if you would also see it as a very brave and courageous thing that maybe you shouldn't be penalized for in such the way that you have been. We have to frame things as a question, so I just thought I'd ask how you feel about that, if you felt it was a very brave thing to do.
Sort of, I guess, but you know, I really cared about the people that worked for me and that I work with, and I you know, like I said, a lot of them were high risk, and I was given the option to continue working from home, but in doing that, I had to support the activities of people that were still out working in the field in what I thought was illegally, because we were clearly not essential and just doing it anyway. So thank you.
Thank you. Are there any other questions? Seeing none, we appreciate you being here today. Have a great weekend. Next is Bernd Erickson, followed by Roxanne Kai Petrovich, followed by Terry Gerstein. Welcome. You may begin your testimony.
Thank you very much. Senator Hickman, Representative Sylvester, and members of the Labor and Housing Committee. My name is Bernd Erickson. I'm a resident of Kittery, and I'm here today to testify in favor of LD 1711. A few weeks ago, I was working at Dollar General. I watched my manager, who was a salaried worker, expecting to work 40 hours a week, working twice that without breaks, without overtime, without any form of thanks or additional compensation. I witnessed deliberate understaffing in order to exploit that salary. These blatant worker violations were frustrating, and I watched my salaried manager quit after working 70 hours weeks for 6 weeks without being compensated for the extra time. She was making less than minimum wage when you looked at her salary and the hours being worked. This was clear exploitation of a salaried worker. There were times when it would be too busy at work to take a break, impossible to do when a store is understaffed. At times, I would actually clock out and work through my break time so I wouldn't get written up for not taking my break or not finishing an assigned task. I would most commonly work on unpaid break in order to put away refrigerated items. The delivery truck that showed up when I was on break, and I was the only person with the authority to receive the truck. These are some of the most stressful nights to work, working 9-hour shifts and not having the time to eat or stop working. When I first started working at Dollar General, I signed a document that took away my right to pursue legal action. If I experienced any discrimination, wage theft, or harassment, instead, if I brought something up, it would have to be through private arbitration, typically in location and through a format of my employer's design. The ability to be a whistleblower protects both workers and customers from bad practices many companies keep practicing in. I quit my job at Dollar General because of the injustices I was seeing and experiencing. After my manager walked out because of the immense expectations she was under, I thought management would contact us to make some solutions to our staffing shortage at our store. That didn't happen. It looked like our corporate office didn't care about us at all. So I, along with my coworker, decided to quit. Workers deserve to be treated better, and if we are dealing with issues at work, we deserve for those issues to be taken seriously. We deserve to have the right to file a complaint publicly and hold corporations accountable. That's why I'm here today, to advocate for workers like my former manager, like myself, and many others who want and need to be empowered to hold lawbreaking corporations accountable. I want to make sure those who experience wage theft, discrimination, and forms of harassment are able to move forward and file a complaint outside of the closed doors of a corporation. Please vote to support LD 1711. Thank you very much for listening.
Thank you for your testimony, Mr. Erickson. Are there any questions from the committee? Chair recognizes Representative Warren.
Thank you very much for your testimony. It seems that you and those that you work with were at different points during this pandemic over the last more than year, essential workers, quote unquote, and yet are put in this situation of it just making it very difficult to do what we deem essential work. I am wondering if that's how you see this, or if you'd characterize it in some other way. But it seems that it's hard to believe that this is how we're treating essential workers in our state.
I do see it that way. The being called an essential worker and then being an abandoned essential worker didn't make me feel all that essential at all.
Any other questions from the committee? Mr. Erickson, did I hear you say in your testimony that before you took the job at Dollar General, you signed a document?
Yes, sir, for arbitration.
And do you still have that document in your possession?
In my possession, no.
Okay. Yeah, I was just wondering if we could get an example of that kind of document that workers are expected to sign before they receive a job like this. But I will ask our analysts to look into that, and maybe we can get that document from Dollar General, notwithstanding the issue in front of us. I appreciate you testifying in front of us today. Good luck with your future endeavors, and I hope you have a great weekend. Next is Roxanne.
Thank you very much for listening.
You're welcome. Next is Roxanne Kai Petrovich, followed by Terry Gerstein, followed by Jeff Young, followed by Michael Cabetta. Welcome.
Hi, Senator Hickman and Representative Sylvester and other members of the Labor and Housing Committee. My name is Roxanne Kai Petrovich, and I am a volunteer through Maine People's Alliance and a resident of Woodstock, Maine. I'm here today to testify in favor of LD 1711. Before the pandemic, I worked at a fast food restaurant in Western Maine. I worked hard and was even promoted to shift leader. I eventually had to leave my job because a coworker repeatedly sexually harassed me and other women at my job. When I brought it to my supervisor's attention, I was told that they wouldn't do anything about it because there wasn't any proof, and it was a he said, she said situation. Even though they were required by law to investigate and take action against sexual predators, my employers were not willing to take the necessary steps to ensure a harassment-free workplace. Instead, I was completely pushed aside. So I did some research myself and found out that even if I had wanted to go to court, I wouldn't have been able to. I had unknowingly signed away my rights to do so when I started my job. Instead, I would have had to go through a closed door process called arbitration, where the rules would be set by my employer, and I was completely discouraged from moving forward. There was no way to make my employer respect my rights. That was when I left my job. It was a tough decision to make at the time, as I was in the process of planning a wedding and I have a young daughter, and I ended up being without an income for some time. I didn't want to work somewhere that didn't take an issue like that one seriously. I know I'm not alone in this story, and what I'm sharing can sound familiar to many people. And I know I'm not the only person who has experienced sexual harassment and felt like nobody was listening when I tried to do something about it. That is why I'm here today, to speak not only for myself, but for everyone who has had a similar experience to my own, and to help protect future workers like my daughter when she joins the workforce. Too many workers are kept quiet, because of forced arbitration. Our voices deserved to be heard and not shut down by our employers. We need the opportunity to speak up against wrongdoings. I urge you all to support this bill and make sure that workers have a voice. Thank you.
Thank you for your testimony. The chair recognizes Representative Drinkwater.
Thank you, Mr. Chair. You said you had to sign your rights away to pursue the matter. And we asked the previous person that testified, do you still have that form that you've signed? And in case you have it, could you supply it to this committee so we could see what you're talking about?
I do not have a copy of the arbitration agreement that I had signed.
Thank you.
The chair recognizes Representative Warren.
Thank you very much for your testimony. As someone who has been sexually harassed and retaliated and ultimately let go by an employer on those grounds, I feel in Maine, I feel like there would not be a document that I could perceive as reasonable or should be lawful that would make the harasser also the sort of judge and jury in these type of arbitration processes. And yet this in effect is the reality, unfortunately, in so many cases. And so I'm just wondering if you also see this system maybe as well intended, but as maybe we have greater equity in society and in the workplace, we find these systems are just kind of end up creating such a disproportionate set of power relations that are wholly inappropriate. I'm wondering if you also see the system may be well intended, but it's just not really functional always.
I do see it that way. The arbitration agreement, from my understanding, I can't really speak to the technical parts of it, but from my experience, the arbitration was set to protect the employer, which is something that we do need to protect also, because as Senator President Troy Jackson had mentioned, there has been or may be cases of frivolous lawsuits, and employers need to be protected just as much as employees. But in the case of forced arbitration, it creates a very big power imbalance where it is meant to discourage workers like myself from moving forward, because what chance do we stand being put into a room where we are being judged by the people we're speaking out against in the rules that they set? It seems very unfair.
Are there any other questions from the committee? Thank you again for your testimony. I want to make it clear that when I ask for the document, it's not because I don't believe you signed it. I would imagine that when you accept a job, you sign all sorts of things so that you can get the job. And I'm wondering at what point in the process did you have to sign this document?
The document was signed at the hiring. I had gone in for an interview, and then I got the call back that I was hired and asked to come back in to sign the documents to start working and provide social and all the information needed by an employer. It's not something I was familiar with at the time. I had no idea what forced arbitration was. And if I did not sign all the papers, then I would not have been able to be hired.
That is completely understood. I think because this is the Committee of Labor and Housing and we discuss these issues often every day, we need to know just what it takes to become an employee of, you said this was a fast food restaurant?
Yes.
And may I assume that your job was minimum wage, or were you making more than minimum wage? It really is technically none of my business, but I'm just curious.
I started at minimum wage, and as I was promoted to shift leader, I had a couple cent raise from minimum wage.
A couple cents, you said.
Yep.
Okay. Thank you for being here today again. And, you know, the situation that you testified about is heartbreaking and far too common. So I hope that you feel good about being here and letting us hear your story. And I hope you have a great weekend as well. And good luck.
Thank you for the opportunity.
And good luck with your daughter.
Thank you.
Terry Gerstein, I apologize if I pronounced that incorrectly. You are next, followed by Jeff Young, Michael Cabetta, and Hugh Barron.
Good afternoon, Senator Hickman. My video has been disabled by the host. Okay. All right, great. Thank you. So good afternoon, Senator Hickman, Representative Sylvester, and members of the Labor and Housing Committee. My name is Terry Gerstein. I am the director of the State and Local Enforcement Project at the Harvard Labor and Work Life Program. I'm also a senior fellow at the Economic Policy Institute, and I'm here speaking in my personal capacity. Previously, I worked over 17 years enforcing workplace laws in New York State at the AG's office as the Labor Bureau Chief and in the New York State Department of Labor as a Deputy Commissioner. And I'm here to give you some of my perspectives on this legislation as someone who's spent my career in government enforcing workplace laws and currently works with government enforcers all over the country who are enforcing workplace laws. So we've heard a little bit about the overall context, that there's research showing really high rates of violations. We know that government agencies to enforce these laws are severely underfunded. And we heard about Maine having only 5, soon to be 6 investigators. And we've heard so far from workers about their own, really powerful experiences. At the same time, forced arbitration has spread throughout the country. An estimated over 50% of employers use forced arbitration, and that's projected to reach over 80% within a few years. As we've heard, workers don't necessarily, it's very common for workers not to even get a copy of the contract because they're boilerplate and signed right when people start the job as a condition of employment. And what forced arbitration does is that if people need redress, it really places a lot more pressure on government enforcers, and it places more need for government enforcement. We have always relied on private lawyers and public interest lawyers to bring lawsuits as a pillar of the structure of enforcement. That's why all of these laws have attorney's fees provisions. And so whistleblower proposals like LD 1711, it's actually a pretty simple way of addressing the current crisis in enforcement and so many workers being blocked because of forced arbitration. It's similar to California's PAGA law, similar to False Claims Act laws, which exist in most states. And in the development of the law, I reviewed it and gave some feedback from the perspective of an enforcement official. As someone who spent my career in government, I understand the balancing that has to happen, and you don't want employers burdened by lawsuits over de minimis issues or lawsuits that the state's interests aren't really served by. But this proposal, I just want to share, it has measures to ensure that whistleblowers serve the state's interest. The case is initially filed with the AG or responsible state official, and the state has the first bite at the apple. So the state has 180 days to investigate. If the state decides not to do the case because of resources or triage or other reasons, and the case is filed by a private entity standing in the shoes of the state can intervene in the lawsuit. Any proposed settlements have to be submitted to the AG or the responsible state official, and it also has to be approved by the court. And then the penalty is the majority of the penalty goes to the agency that's doing enforcement, and a portion goes to workers injured by the violations. A few observations: the state was never meant to be the sole enforcer. We really do need private attorneys to play this important part. And I certainly always felt terrible when we turned away workers. And I know the other government lawyers that I speak to in other states feel the same way. They're really devoted to their mission. And this kind of legislation it not only helps workers get redress when there's cases of wage theft and harassment and discrimination, but it also helps deter violations because employers know that there's much more likely to be a consequence. And my final point is just that legislatures pass laws protecting workers from wage theft, discrimination, harassment. And if half or more of people can't bring cases because of forced arbitration, it basically uses a contract provision to nullify people's rights and circumvent the legislature's intent. I'd be happy to answer any questions.
Thank you for your testimony. The chair recognizes Representative Drinkwater.
Thank you, Mr. Chair, and thank you for being here. Can you tell me how many other states have similar laws that we are examining?
So California has the Private Attorney General Act, which is specifically on labor and workplace issues. But I think a really good analog for this law really is the False Claims Act, which I know that Maine does not have, but around 30 states and the federal government do have False Claims Acts. And to me, it's very akin to the False Claims Act in that you're having a private attorney stand in the shoes of the state and bring a claim on the state's behalf. So with False Claims Acts, obviously, the cases are brought in relation to fraud against the government, while this involves other kinds of violations of workers' rights. But the basic concept.
Thank you very much. I appreciate that. You've answered my question. I don't want to take the other panelists' time. Thank you.
Drinkwater, I'd appreciate it if you would let the testifier finish answering your question.
Certainly, sir. She did answer my question. I was asking for a number.
I understand, but we don't cut people off who testify in front of this committee. Please.
Well, you've cut me off many times, Mr. Chair.
Don't cut the public off when they are testifying in front of this committee, Representative Drinkwater.
I understand, sir, but I asked a question of numbers and she answered the number.
I do not want to argue with you. We're not going to cut off the testifiers who testify in front of this committee, no matter how long their answer is. Can we get that straight? Thank you. Please continue your answer, Ms. Kirsty.
So there are 30 states that have False Claims Act laws that allow private lawyers to sue on behalf of the state. And in those states, there's generally a robust qui tam bar that brings these whistleblower cases and recovers considerable money.
Thank you. The chair recognizes Representative Cuddy.
Thank you, Mr. Chair. Thank you, Ms. Gerstein, for being here today and for your testimony. I was wondering if you could draw the sort of a straight line between the testimony that we've heard around the forced arbitration and then how this bill would impact an individual's ability to get past something like that.
So that's a great question. So there is Supreme Court precedent that government agencies are not bound by forced arbitration because obviously a government agency hasn't signed the arbitration agreement. And so the way that this allows people to still bring these cases is that they're not bringing the cases on their own behalf, they're acting on behalf of the state. So it is a state action, it is a state enforcement action. And there has been case law in California, there have been challenges to California's Private Attorney General Act, specifically on the issue of whether it's preempted by the Federal Arbitration Act, and it has not been found to be preempted precisely for this reason. It's a government action, not an action by a private individual.
Thank you very much.
Are there any other questions from the committee for Ms. Kirsty? Thank you for being here today.
Thank you.
Enjoy your weekend. Next is Jeff Young, followed by Michael Cabetta, followed by Hugh Barron, followed by Destiny Hellman Sprague.
Good afternoon, Senator Hickman, Representative Sylvester, and distinguished members of the Labor and Housing Committee. My name is Jeffrey Neal Young, and I'm here today to testify on behalf of the Maine Employment Lawyers Association, or MELA. MELA is a group of about 75 attorneys here in the state, and we're the ones that find out that individuals knowingly have signed these forced arbitration agreements when we try to go forward and represent them with respect to their claims. First has laid out the mechanics of this bill. I've referred to it at some length at the end of my written testimony, so I'm not going to spend my time doing so here, but would be happy to answer questions about it. The committee has heard me testify on a number of bills this session. I want to say to the committee this afternoon that I think this is the single most important employment bill to come before it in this session. Why do I say that? I say that because all of us, as workers, as Mainers, as Americans, are losing our right, or we're losing our rights through the increasing use of forced arbitration agreements. This legislature, Congress, city councils, all of representatives like you enact laws in the hope of enacting or of improving rather people's lives. But those lives aren't, or those laws rather, are not worth the paper they're written on or the cloud that they're stored in if they can't actually be enforced. And that's exactly what's happening here through forced arbitration. Forced arbitration, which was virtually unknown 30 years ago, is pernicious because it serves not just to repress claims, but to suppress claims altogether. It does that by requiring employees to bring their claims privately and individually rather than publicly and as a group. I can't really afford to take a case for a single individual who's owed $1,000 in arbitration. I need to be able to pursue those claims as a group. But claim suppression is not the only evil. All of us benefit from having claims tried in a public tribunal, not in a private, closed-door, secret proceeding. When claims are tried in a court of law, the public learns if someone has erred, if somebody has stolen a worker's wages, has discriminated, or as on the basis of race or sex or disability. The last point that I want to make is this. I know in testifying before the committee that the committee's been concerned about statistical evidence. At the back of my paper, I list over 225 main employers doing business here that use these forced arbitration agreements. And just to wrap up, since two of the committee members asked about examples of agreements, I have roughly 20 samples of agreements that are being used right here in Maine. They're not part of my paper, but I'd be happy to furnish them to the committee in advance of the work session so that you can see the actual language of these agreements. Thank you for your time and for hearing me throughout all of this session. I'd be happy to answer any questions.
Thank you, Mr. Young, for your testimony. And yes, we would be very appreciative to see an example of some of these documents that employees have to sign before they can do their work. The chair recognizes Representative Warren. Did you have a question? Or?
I was just going to formally ask, and I'm sorry, Chairman, you asked for me, so thank you.
Good. Thank you. Are there any questions for Mr. Young from the committee at this time? Seeing none, thank you for being here, sir. We'll see you at the work session. Next,
thank you.
Michael Cabetta, followed by Hugh Barron, Jesse Hellman Sprague, and Adam Zuckerman. Welcome. Good morning. Good afternoon. You may proceed, sir.
Thank you, Senator Hickman, Representative Sylvester, and distinguished members of the committee. Good afternoon to you all. My name is Michael Cabetta, and I'm Policy Counsel for the ACLU of Maine, a statewide organization dedicated to advancing and preserving civil rights and liberties guaranteed by the Maine and federal constitutions. On behalf of our members, we urge you to support this bill because it would protect the rights of workers who blow the whistle on illegal acts by their employers. Little known to employees, the use of forced arbitration in employment agreements has doubled in scope between the 1990s and today. These kinds of agreements are prevalent in industries that are dominated by women workers, as well as in low-wage fields and industry dominated by women of color. One estimate found that by 2024, forced arbitration will be in place in over 80% of workplaces, covering more than 85 million workers nationwide. Forced arbitration, as you've just heard from Attorney Young, has had the effect of slamming the courthouse doors in the face of victims of workplace harassment and discrimination, and is a massive boon to employers. By sneaking forced arbitration into contracts, employers and corporations are ensuring that even if you did notice what you signed and have the foresight to imagine what you would prefer to do if a dispute were to arise in the future, you have very little choice but to sign. Studies have shown that employees are less likely to pursue discrimination cases in arbitration. This allows discrimination to run unchecked and gives corporations no incentive to prevent or address it when bad acts arise. If enacted, this bill would ensure that bad deeds can still be brought to light and workplace injustices are addressed in court. This bill would involve the Maine Human Rights Commission, the Attorney General, and Department of Labor in efforts by workers to enforce rights that already exist in labor law and rights that echo the constitutional rights that we all cherish. This is entirely appropriate. These agencies have the necessary resources and institutional knowledge to ensure that workers in Maine enjoy their rights in practice and not just in theory. We urge you to vote ought to pass. Thank you for your time and attention, and I'm happy to try to answer questions.
Thank you for your testimony, Mr. Cabetta. Are there any questions from the committee today? This may have already been answered, but I'll ask it anyway. If you sign this agreement for forced arbitration and you are in a protected class and you experience discrimination or harassment on the job, does that mean you cannot bring your claim forward to the Maine Human Rights Commission?
You might have to first go through the forced arbitration process. Yeah.
Thank you. Seeing no questions from the committee, thank you for your testimony, sir, and have a great weekend.
Thank you.
Next is Hugh Barron, followed by Desi Holman Sprague, followed by Adam Zuckerman, followed by Adam Good.
Thank you, Senator Hickman, Representative Sylvester, for the opportunity to testify. My name is Hugh Barron, and I'm a senior staff attorney and Skadden Fellow at the National Employment Law Project, NELP, a nonprofit, nonpartisan research and advocacy organization. At NELP, I conduct research, litigation, and advocacy to address the harms of forced arbitration and class action waivers. NELP strongly supports LD 1711, which would allow workers to file civil actions in the name of the state to enforce their rights under Maine's employment laws. Forced arbitration requirements deny workers the right to go before a judge and jury when their employer breaks the law. They are not voluntary bargain for agreements, particularly for workers in low-wage jobs. Employers unilaterally impose these requirements on workers when they start a job or at any time after they've been hired. They're often buried in the fine print of an employment agreement, but workers don't actually need to sign anything to lose their right to a judge and jury. Employers can use electronic click-throughs where the terms are buried or difficult to access, or even just amend their handbook and send employees an email and deem their continued employment acceptance of that change. And under current law, employers can refuse to hire or fire any worker who refuses to be subject to forced arbitration. Making matters worse, class action waivers incorporated into these requirements prevent employees from banding together to challenge employer lawbreaking. Underpaid workers are the most impacted by wage theft and forced arbitration clauses, and particularly Black workers and women workers. Forced arbitration heavily favors employers in several ways outlined in my written testimony. Faced with the reality of proceeding alone against their employer in a stacked forum, research has shown that 98% of workers whose claims are subject to forced arbitration simply abandon their claims. A new report I co-authored with Elizabeth Campbell and attached to my written testimony demonstrates how forced arbitration is helping employers pocket stolen wages in Maine. NELP found that in 2019, forced arbitration helped employers pocket over $40 million owed to low-paid Maine workers. $40 million, specifically from over 19,400 private sector non-union workers earning less than $13 an hour. Again, because these workers are forced to proceed one by one in a stacked forum, 98% of them will never file a claim to recover in the first place. While Maine's Department of Labor is not restricted by forced arbitration requirements, nor is the Human Rights Commission, the Department of Labor in particular cannot deal with the enormous wage theft enabled by forced arbitration due to the agency's low staffing levels and resources. LD 1711 would allow workers to stand in the shoes of the state and seek civil penalties, injunctive relief, and declaratory relief for wage theft, as well as for violations of the state's discrimination laws. Because a majority of penalties recovered in these actions would go to the state, it would also generate significant new revenue for DOL, the Attorney General's Office, and the Human Rights Commission, allowing them to increase staffing levels and expand their capacity. In addition to California, to address a question asked earlier by the committee, the state of Colorado actually adopted a whistleblower statute recently that adopts the enforcement model present in this bill. Thank you for the opportunity, and I'm happy to answer any questions about this bill or about forced arbitration more generally.
Thank you, Mr. Barron, for your testimony. The chair recognizes Representative Drinkwater.
Thank you, Mr. Chair. Thank you, Mr. Barron. Just listening to the testimony, obviously there's a problem with the forced arbitration having to be signed. Wouldn't we as a committee be better off to say no more forms of forced arbitration?
Well, that would, in theory, be great, and we would certainly support that if it were possible. Unfortunately, the Supreme Court has pretty squarely ruled that out. So there's a preemption clause in the FAA, and the Supreme Court has held that the Federal Arbitration Act preempts states from taking action in this area against just as the Supreme Court puts it, discriminates against arbitration as opposed to other contracts.
Thank you.
Mr. Barron, will you be able to provide that Supreme Court decision to our analysts for the work session?
Yes, I'm happy to provide some. It's been several decisions, in fact, on that. However, as Terry Gerstein testified earlier, there have been numerous attempts to challenge California's Private Attorneys General Act as preempted, and the Supreme Court has rejected multiple attempts and has denied certiorari on them. So at this time, there is no federal precedent, there is no binding precedent that prevents Maine from pursuing this bill.
And do you know how recently Colorado enacted a law similar to this, as you said in your testimony?
Yes, and it was last year. It's HB 20-1415, the Whistleblower Protection Public Health Emergencies Act. And the difference with that bill is it was targeting a specific set of harms, particular set of employment violations that is narrower than the bill you have before you. But it adopted the same kind of remedy where whistleblowers can stand in the shoes of the state and pursue civil actions, and the majority of those penalties go to the state if they are successful.
Thank you. For Mr. Langland, if you could be sure that we see a copy of that legislation from Colorado for the work session. Appreciate it very much. Are there any other questions for Mr. Barron from the committee? Seeing none, thank you for being here today and have a great weekend.
Thank you.
Dusty Holman Sprague is next, followed by Adam Zuckerman, Adam Good, James Mayall, and Rachel Deutsch, followed by Andrew Mason and Joseph Kubetz. Good afternoon. The floor is yours.
Good afternoon, Senator Hickman, Representative Sylvester, and members of the committee. I'm Dusty Holman Sprague, and I'm happy to join you here today on behalf of the Maine Women's Lobby. We advocate for public policy that increases the health, wellness, safety, and economic security of Maine women and girls. And in that capacity, we are here in support of LD 1711 and thank President Jackson for sponsoring this bill. As you've heard here today, discrimination in the workplace, yes, even in Maine, especially gender-based discrimination, is still pervasive in our communities, despite the increase in awareness in recent years. In 2019, a full quarter of complaints filed with the Maine Human Rights Commission were based on sex or gender identity, and half of Mainers experience sexual harassment in the workplace, women at 3 times the rate of men. Women are also significantly more likely to experience wage theft or wage violations, and they make up a greater share of women's earnings. This discrimination is even more devastating when women belong to additional marginalized groups, such as women with disabilities, women of color, and trans women, who all experience greater economic injustices as a result of discrimination. Maine has recently made changes that ensure equal pay, but without enforcement and accountability, the protections of the law aren't accessible to many Mainers. In addition to being more likely to experience workplace harassment or inequity, women in Maine are also more likely to experience barriers to seeking redress. According to a recent study, 2/3 of female employees report that they believe if they reported workplace violations, their career or their job would be harmed. This is why fair and equal access to workplace remedies is so essential to women's economic justice. Only when Mainers can engage in impartial, unbiased, and open civil processes can they move their claims forward with confidence. We have heard that we are under-resourced in Maine, but without the access being expanded, individuals are forced to engage in confidential or closed-door negotiations. This bill seeks to build the access that we need for enforcement in Maine. It creates a process to ensure that all workers or have a pathway to justice. I worked in sexual violence and sexual harassment for many years. And one thing we know is that survivors and victims need many pathways and options. LD 1711 creates those options and helps to ultimately create more protections and a safer, more equitable Maine. I hope you will join me in supporting this bill. Thank you.
Thank you for your testimony and being here today. Are there any questions from the committee? I think the committee wants to move on to the rest of the afternoon.
Thank you.
For being here. Next up to testify is Adam Zuckerman, followed by Adam Good, James Mile, Rachel Deutsch, Andrew Mason, and Joseph Betts. Mr. Zuckerman, whenever you are ready. Good afternoon. The floor is yours.
Thank you for having me. Senator Hickman, Representative Sylvester, and honorable members of the Joint Standing Committee on Labor and Housing. My name is Adam Zuckerman, and I'm the lobbyist for the Maine People's Alliance. Our 32,000 members stretch from Kittery to Fort Kent. We are committed to creating a state of Maine where everyone has what they need, everyone contributes what they can, and no one is left behind. Thank you for the opportunity today to testify in favor of Senate President Jackson's act to enhance enforcement of employment laws. Employers are getting away with wage theft, discrimination, and sexual harassment. For the past 2.5 years, I directed the Maine Small Business Coalition, which represents over 4,000 community-rooted small businesses across our state. I had countless conversations with small business owners. They had a lot of concerns: a lack of access to childcare, a lack of affordable health care, an underfunded school system that wasn't properly training young adults for the workforce, and a tilted tax code that prioritizes big box stores over mom and pop shops. I could go on and on and on. You know what none of them were concerned about? Too much enforcement of labor laws. In contrast, many of them were concerned about big box stores, fast food joints that cut so many corners it made it hard for Main Street businesses to compete. That flagrant flouting of our labor laws not only hurts workers and allows the abuse to continue, it also corrodes faith in our institutions and drives a race to the bottom. When workers see regular labor violations and don't see any enforcement, they stop reporting them, and bad actors only ramp up those violations. When other businesses see their competitors flaunt our laws and get away with it time and time and time again, they start to think, well, why should I follow the rules? That creates a race to the bottom that hurts workers and hurts the grand majority of small businesses that play by the rules. The Maine Department of Labor and the Maine Attorney General's office have talented, hardworking staff, but not enough resources to prosecute every lawbreaking company. That's why lawsuits by victims of wage theft or sexual harassment are an important tool to hold bad actors accountable. This committee has the ability to help end impunity and create a level playing field for workers and small business owners who play by the rules. I urge you to vote ought to pass. Thank you.
Thank you for your testimony. Are there any questions from the committee? Seeing none. Enjoy your weekend, sir. Adam Good, you are next.
Good afternoon, Senator Hickman, Representative Sylvester, and members of the Labor and Housing Committee. My name is Adam Good, Legislative and Political Director of the Maine AFL-CIO. I think we all want to agree that workplace laws and rights should be followed and enforced. When we enact things like earned paid leave laws or higher minimum wage laws, it's our shared expectation that the law be followed and those rights be enforced, and that we have the tools to ensure compliance. Violations of workplace laws are all too common. It's true across the board, from wage theft to misclassification, health and safety violations. In the example of wage theft alone, in the 10 most populous states, 2.4 million workers lost $8 billion annually to minimum wage violations. So it's essential that we have robust, effective systems of enforcement. You've heard today that there is a crisis in enforcement. State and federal departments of labor and attorneys generally enforce workplace standards and seek wages owed to workers when the law is broken. There's always been a recognition that public entities were not designed to be the primary or sole mechanism of enforcement. If I'm trying to think through how to add things to the conversation today, I would just highlight and reiterate what Senator Jackson said about the number of DOL wage and hour investigative staff to workforce. From 1977 to 2017, the number of full-time DOL employees decreased from 702 to 552, meaning the total agency staffing decreased by 21%. The DOL's budget decreased by 59% in that time frame when adjusting for inflation. At the same time, Maine's workforce grew. It was 61% larger in 2017 than it was in 1977. If Maine's DOL had merely kept up with the state's growing workforce, it would have over 1,100 full-time employees today. This, combined with the rise of forced arbitration, which you've already very clearly heard about, especially from the three people that shared personal stories first, has combined to make a major problem when it comes to enforcement responsibility within the Maine Department of Labor, especially in its dramatically understaffed and underfunded capacity. If I could use just the final parts of my time, we think that LD 1711 has a really clear system for enforcement that will uphold the most basic bargain, that your rights will be protected and that the law will be followed. It's a model built on direct worker experience. If we use an example of a routinely required work of extra time, unpaid off the clock, under 1711, the worker files complaint with DOL for unpaid wages. DOL can investigate the claim and resolve it through their administrative processes. If MDOL does not have the capacity or decides not to resolve the claim, the whistleblower can bring a suit forward to collect penalties, not damages, on behalf of the state and impacted workers. And if a judge finds the corporation broke the law or imposes a penalty, most of that penalty goes to MDOL for enforcement, with a portion going to the whistleblowers. We think that's a good process. We appreciate you hearing all our testimony today. I'm happy to attempt to answer any questions.
Thank you, Mr. Good. Chair recognizes Representative Bradstreet.
Thank you, Mr. Chair, and thank you, Mr. Good, for being here. Just a quick question. I think you mentioned the top 10 states of $2.8 billion lost through workplace theft, or something along those lines. Do you have any idea where Maine ranks in that? Or do we have any figures anywhere? Or maybe the department has some figures.
I do not have Maine specific figures. We think this is a clear problem. And I think if I were to lift up one thing, some people might say that the state has all the resources to deal with this, and this isn't an issue in Maine. We haven't found that to be true. And I would also raise up that Maine only has the capacity to respond to complaints, not to proactively audit employers for compliance. So there's just a big gap in between what Maine is doing and could be doing.
Thank you.
Any other questions? None. Thank you for being here. Have a great weekend.
Enjoy your weekend.
Next up is James Mile, followed by Rachel Deutsch, if she's here, followed by Jeffrey Kobetz. Excuse me, Joseph Kobetz. Mr. Mile, is yours.
Good afternoon, everyone. My name is James Mile. I'm a policy analyst at the Maine Center for Economic Policy, and I'm here before you to testify in support of LB 1711. As we know, the COVID-19 pandemic, which has infected almost 67,000 Mainers and claimed the lives of more than 800, has highlighted the risk that Mainers face every day in the workplace. And I know you've heard from several people who have spoken to that today as well, and the lack of recourse that many workers have against employers who flout safety guidelines or wage and hour laws. LD 1711 would help to address the lack of state capacity and to give workers another avenue to seek justice. I wanted to give some sort of general overview of the sense of how much occupational risk of exposure to COVID-19 we've seen over the past year. We don't have I haven't been able to find a lot of data in Maine, particularly about workplace risks, but there are a number of national studies. One national review of COVID-19 cases and deaths through September of 2020 found hundreds of thousands of cases among nursing home workers and workers in the food industry. And additional studies at the state level have found similar results. In California, Massachusetts, and Washington, COVID-19 deaths among workers were not only concentrated in healthcare, agriculture, and food processing, but also retail, restaurants, warehousing, and maintenance. I think it's reasonable to presume that workers here face similar risks. Trying to enforce some of the safety guidelines has been very difficult during the COVID-19 pandemic. The data we had through September of last year showed that the federal OSHA and its state partners had received about 37,000 complaints about COVID-19 in the workplace, but they'd only been able to investigate 3.5% of those, none of which were in Maine. And at the state level, it seems like we've also had a lack of capacity to be able to investigate that. The enforcement relying on reports to DECD only found there are only 65 complaints that were acted on by the department there, which seems like an implausibly small number given that there are about 50,000 businesses in the state. You've already heard about lack of capacity at DOL, so I won't talk too much about that. I will say that sort of the information we have on the Private Attorneys General Act in California has shown that it has been relatively successful in empowering workers and returning millions of dollars in lost wages and wage theft. I know Representative Bradstreet asked about sort of the scale of some of the violations, and especially wage theft in Maine. MECEP's State of Working Maine 2019 report sort of took a look at this. We did a survey and we asked workers how many, whether they'd experienced situations that could count as wage theft. And it was the equivalent of several thousand workers that they had, which is obviously much smaller than the several hundred, I believe, that the Department of Labor is able to investigate every year. We did run I ran numbers sort of based on the same study that Mr. Good just cited about the billions of dollars in wage theft. The number that we got from Maine in 2018 was, I believe, $32 million in wage theft every year based on sort of the same methodology that they used. So hopefully that's helpful. I'll urge you to vote or to pass on the bill, and I'm happy to take any more questions.
Thank you, Mr. Meyer. Are there any questions from the committee? Seeing none, thank you for being here, sir, and have a great day.
Thank you. You too.
Next up is Mr. Joseph. Good afternoon.
Good afternoon, committee. I'm going to stand here. It's all right. Thanks so much for being here. It's nice that we live in a state where people care enough to try and tackle these issues and take them on. Feel free, by the way, this is, I'm not used to testifying in front of committees too much, so this is a stretch for me. So metaphorically, feel free to stretch literally. I know you've been sitting for a while, so I want to be kind to the members here. So I'm from Maine. I've worked a wide variety of jobs. I think my first job was working at a sandwich shop. I've washed dishes, I've bussed tables. I've worked at greenhouses. I've cleaned toilets, worked in childcare, worked as a male nanny, done all kinds of things. I've worked in hospitals, doctor's offices, kind of the whole gamut. Had terrific coworkers, inspiring people, awesome supervisors, people who made you want to work harder and get on board with the mission of whatever the company was, whether it was taking care of kids or serving a great meal in a restaurant. Worked with some awesome people. And at the same time, I think it's important to remember that there are some dramatic examples, both in history and in my own life. I'd encourage members to look at the Triangle Shirtwaist Factory fire in New York City. That's a famous example of people being locked in a factory and not being able to escape, and 100 and some odd people died because the employer locked the doors so that they couldn't leave for a break. I worked for a company in southern Maine a number of years ago that actually created an artificial second company that they didn't tell us about at all. And any hours that we worked for overtime were ticketed to that artificial company so that we wouldn't be paid any overtime. Completely egregious, obviously. And I want to note here that, I didn't speak up then because I was frightened to, as I imagine other employees might be. And there's a career coach in Portland named David Lee who talks about having courageous conversations in the workplace is a key to improving workplace culture. And I think we might view that the same way, that an employee who's brave enough to bring a lawsuit is actually having a courageous conversation and saying the Maine brand, what we want to create, it's kind of like a parent saying to a 13-year-old, go and do all kinds of cocaine or something, what have you. We're going to have a conversation about that versus we care enough to have this conversation. So I definitely support removing all the obstacles to having those conversations, and happy to answer any questions.
Thank you for your testimony today. And for the record, for people who are listening, can you please state your name and where you're from?
Sure, my name is Joe Kubetz, and I live in the beautiful city of the Phoenix, Portland, Maine.
Thank you. Chair recognizes Representative Warren.
Thank you very much for your testimony. And because you mentioned the shirtwaist factory fire, I just wanted to ask if you could make that connection that I think we've heard certain other people make to that instance where, if I'm not mistaken, it was majority women and immigrant women, and that in these instances, it's our systems or structures are just set up to have people who are already disenfranchised in some way be disenfranchised in these contexts as well. So just I think that thinking about the relationship to gender equality or these other elements is significant in an instance like with this bill. And I appreciate you bringing the factory fire up. So just if you had any further comment on that.
Yeah, I couldn't agree more that all workers deserve a fair shake, and we're trying to build a culture where the Maine brand, it's iconic, the Maine brand. People love Maine vacations, Maine restaurants, Maine lobster, and we want to create a brand here where the employer-employee relationship, is solid, is something that we can stand up about. And definitely I can see that in that particular job I had. It was, I was working relatively close to a minimum wage job, which I was told by a friend at the time, that is so not right to take advantage of folks who are making, just a teeny fraction over minimum wage. And as you aptly put it, Representative Warren, a lot of those low wage jobs are held by minorities, women, disenfranchised people, all kinds of groups that we know want to have a more fair shake. So I definitely believe that in terms of the almost unanimous support for the racial impact justice bill that's been brought up this legislative session, I think this definitely fits in with that. So I appreciate you pointing out that there's certainly a connection with making sure that all Mainers get a fair shake.
Chair recognizes Representative Rader.
Thank you so much, Mr. Chair, and thank you, Mr. Kibitz, for being here. You mentioned the Triangle Shirtwaist Fire, and you have spoken at length about wage theft issues that you yourself had spoken of. I'm interested to hear if you have any anecdotal sort of modern day instances of workplace safety along the lines of Sarah Jones, who lost her life on a film set in Georgia recently due to workplace mismanagement, in which a whistleblower law might have kept her alive. So have you yourself experienced any safety issues that would have benefited from a whistleblower, or do you know anyone who has?
I would certainly say that there's instances of that all the time in terms of work conditions. I worked for a company that was a little bit slow to provide hearing protection to people, and I did speak up and eventually went to, the human resources support folks there eventually. But me and other employees at that company, I think, probably were a little bit reticent, as anyone would be, to try and speak. When you need a job, you've got to, work hard and sort of do what the employer wants. And I think trying to have a reasonable balance between the two so that we can also empower employees to actually create in the long term, it's actually going to help employers because you're going to retain employees, you're going to have a better culture. In terms of other safety issues, I'm sure there are many parallels. I'm just relating back through my time. But I imagine in the examples that I've shown that other people who've worked different jobs in terms of safety, I imagine it wouldn't be hard to find other factory examples, other examples in workplaces where safety was an issue. So it's not just wage, but also people's health, people's lives. Yeah.
Thank you so much. And thank you for bringing up the point about the hearing protection. I appreciate that.
Are there any other questions from the committee? Seeing none, thank you for being here today and have a great weekend. So I have time to testify in favor of this bill. If there's anyone who's attending who wishes to testify in favor of this bill who hasn't signed up, please raise your hand. Seeing none, I will now turn to testimony in opposition to the bill, and I am wondering if the Attorney General wishes to testify on this bill today or is just listening. Attorney General Fry?
Yes, can you hear me?
Yes, we can hear you. Would you like to testify in opposition to this bill before the committee today, sir?
Yes, I would. I don't know if my camera's on though.
Yeah, I'm gonna promote you. And you ought to be able to turn on your video at this time. Let me know when you can turn on, just try to turn on your video, let me know. Yes, this is working. We'll just give the Attorney General an opportunity to get through the wormhole and settled here. Good afternoon, Attorney General.
Good afternoon, Senator Hickman, Representative Sylvester, members of the Labor and Housing Committee. I'm going to do my level best to watch Representative Cuddy so that I don't go over my 3 minutes. My name is Aaron Fry. I reside in Bangor, and I have the honor of serving as Maine's Attorney General. I'm joining you today to express some opposition to 1711. First, I want to be crystal clear. I hope there's no mistake about this. I strongly support the vigorous enforcement of Maine's labor laws. When an employer violates wage and hour laws or any other laws that are designed to protect employers from unfair or abusive practices, it is important that that employer be held responsible. So the opposition that I have today stems more from my concern about how it's going to impact the current legal authority of my office and my belief that passage is not going to yield meaningful results. So as many of you know, the Attorney General is a constitutional officer that is endowed with both statutory and common law powers. It is the job of the Attorney General to determine how to best advance the public interest. All civil actions in Maine in which the state or one of its agencies is a party must be brought by the Attorney General or one of the Attorney General's designees. By essentially privatizing the initiation and prosecution of litigation involving the state, LD 1711 would interfere with the Attorney General's ability to ensure that the litigation is indeed in the public interest, that positions taken are not inconsistent with other positions that are taken in other cases, and that litigation will not result in adverse precedent that could prejudice the Attorney General's arguments in the future. Additionally, this bill is not an ideal mechanism to ensure greater compliance with Maine's labor laws. Currently, the Office of the Attorney General and the Maine Department of Labor can go to court to obtain a full panoply of available remedies for workers, which includes back pay and liquidated damages in some instances. OAG and MDOL are able to distribute that back pay to affected workers. Now, under current law, MDOL is able to assess a penalty, and that citation is subject to an appeal. The OAG defends those appeals. Now, that penalty is often used to leverage back pay for workers. An action under LD 1711 does nothing more than what the administrative citation would do, except that it allows private attorneys to obtain attorney's fees. It does not allow those private attorneys to obtain back pay claims for workers. So even if a claim is successful, the workers are not going to get what they would otherwise deserve. So a more effective way to enhance the state's enforcement of Maine's labor laws is to better fund the state's enforcement ability. I know been discussed by many before the committee today. There is a current change package proposal that includes not only additional wage and hour law, 2 additional wage and hour law MDOL professionals, but it also includes a second attorney in the Office of the Attorney General to do this work. So creating a culture of compliance where labor laws are not only followed, but where workers are treated with the respect and dignity they deserve is a goal I share with the proponents of this bill. And I'm willing to work with whomever about trying to make that a reality. But 1711 is not likely to accomplish these meaningful results. And I am asking that the committee vote ought not to pass. Certainly happy to answer any questions. And I will make sure that I have my labor AAG available for the work session for more specific questions about how we manage these cases now. I hope I was within the 3 minutes. Thumbs up.
I think you were right on time and not a day late. Just a quick question from the chair, and that is, what jurisdiction does the Office of the Attorney General have to try to settle a matter outside of a forced arbitration contract that an employee has signed?
Certainly, Senator. The state is not, as it was identified earlier, the state is not bound by those agreements that are entered between the employee and the employer. So that arbitration agreement does not apply to the state's ability to bring redress.
So would that also include the Maine Human Rights Commission? Would they have to go through forced arbitration before they could make a claim in front of the commission regarding some harassment or discrimination that's protected under the law?
I am wishing that Director Sneerson was available to answer that question. I want to be careful. I will take the question back. I do have people listening to this. I will make sure we have that answer for the committee.
The director is here. I just thought that she will testify on that and surely be able to answer that question. I just didn't know if you knew already or not.
I don't want to get it wrong, but for sure, that's great.
Chair recognizes Representative Drinkwater.
Thank you, Mr. Chair. Attorney General Fry, nice to see you, sir.
Hello.
Under this proposed legislation 1711, when I'm looking on page 6 and C and D, it talks about how much the claimant is entitled to if they prevail. Is this common practice that if they bring an action, only get 30% of the penalty and the Maine Human Rights Commission gets 55%? And if the Maine Human Rights intervenes, the claimant's percentage drops to 20% and Maine Human Rights gets 65%. Does the AG's office follow the same guidelines as this law is proposing?
So Representative, two responses. I believe that first, I think the Human Rights Commission will be in a better position to talk about how those fees are distributed for their activities, since they handle the human rights side of it. It's my understanding that when Maine Department of Labor is able to obtain a penalty, as I mentioned in my testimony, they may be able to use that penalty to force the employer to pay back wages. So the individuals who were treated wrongly would get some back wages from that. But any penalty award is, it's my understanding it goes to the general fund. So there isn't a distribution structure like what is described here in the bill for these penalties to be distributed out to different places.
And if I may just have a quick follow-up, Mr. Chair.
You may.
I asked an earlier person who testified about, well, why couldn't we just do away with these forced signed arbitration agreements? And they testified that we cannot. Any thoughts on that?
Well, I want to echo the answer. It is a federal issue. So it's federal law that preempts the state being able to prevent forced arbitration agreements. And I would join with all voices to ask the federal government, to ask Congress to change that, to remove the requirement that there be forced arbitration.
Thank you, sir.
Chair recognizes Representative Warren.
Thank you for your testimony. I think during it, I heard you say that basically an acknowledgement of the issues that different working people in Maine have been dealing with, it sounds from what your testimony is stating that it's almost, you almost have a technical issue with this bill, that it just won't do what it's intended to. So it seemed that you were saying that if we fund the chief executive's change package, that will address these issues. But I'm wondering how familiar maybe are you with other legislation in other states that this bill seems in certain ways to be modeled after? Do you think that there is a middle ground to be found here, or do you just purely think greater funding for all things currently in law is all that is needed? And maybe you're just not as familiar with things happening in other states for whatever reason. Just wondering if you could provide me a little bit of clarity with your criticism here.
Yes, thank you, Representative. So first, again, this would be the first time that the role, for at least for the Attorney General's office, for this bill, that the job of the Attorney General to represent the state is being put in a private party, right? So that's really my concern, my primary concern, that this is privatizing the legal work of the state in this small way. So that's number one. Number two is we did work last session. So there was a similar bill, similar legislation that was considered last session. And I think it would be fair to say that my office acted in good faith. I was involved in a number of conversations. My then Chief Deputy, Susan Herman, was involved in a number of conversations. Nancy Makarowski from my office was involved in a number of conversations with the proponents of this bill, trying to find a middle ground, whether it be a pilot project to see how this would work, figuring out how the Attorney General could use current authority to hire outside counsel to engage in this different proactive activity that's been exercised. And I received a polite declination of any interest to be engaging in that middle ground work. So it certainly isn't for lack of effort that my office has tried to engage on a way in which to do better and to confirm that we're reaching people that really do need to have the state getting involved and protecting them from labor violations and employment violations. We just weren't successful at finding that landing pad for that compromise suggestion.
Can I ask a follow-up question?
May I proceed?
Thank you. So just again, for my clarity, I always try to assume best intentions. And so I do believe that, of course, that everyone's coming in good faith. I want to understand, it seems like you're saying fund the change package from the chief executive, but outside of that, there is just no proof that mechanisms like the one proposed through this legislation would be effective at ameliorating the conditions as we've heard them so powerfully discussed during this hearing. So that's my question. Do you believe that there are other mechanisms that could be effective at doing this outside of the change package? Or is it really, you just think that's the golden ticket to addressing the problems that we all seem to acknowledge exist?
Thank you for that reminder that I did not touch upon 2 points in your first question. First, I do think that the additional resources certainly would address the issue that has been raised by proponents as well, right? That the state still lacks resources to be able to pursue these. So I certainly think that should be part of the solution. When we were working on this in the last session, we did reach out, because California is the only other state that has this. I heard Colorado, but I think we need to look into what happened in Colorado exactly as well. We did reach out to California to talk with our counterparts, and we did not walk away convinced that that was a model that was going to work very well in Maine. But again, that's our assessment, and that's just my way of trying to provide the answer that we did look at how this was working in the one state where it's in place now, and we didn't, after those discussions, we didn't walk away with the confidence that was going to meaningfully improve our ability to do what needs to be done for the employees here in Maine. So that's what we tried to do and what we weren't able to get confidence on.
The chair recognizes Representative Bradstreet.
Thank you, Mr. Chair, and thank you, Attorney General, for being here. My question is actually pursuant to the questions that Representative Drinkwater asked regarding the distribution of civil penalties recovered And the way it's proposed to be distributed to various commissions, is that not the practice, or is it illegal to do it that way? I know you said it goes into the general fund normally, but is it legal for it to go to the separate funds such as this?
I don't, I'm not aware of any restrictions that would prevent the legislature from directing how, these different settlements would be directed. So I'll confirm that answer, but, the legislature does have the authority to direct how any settlements that are obtained are then directed.
Okay, good. Thank you. Appreciate it.
Chair recognizes Chairman Sylvester. Chairman Sylvester, do you have
Thank you, Mr. Chair. Thank you, Mr. Chair. Welcome, Attorney General Fry. How are you?
Hello.
So my question has to do with the precedent. I understand that that both the DOL and the Attorney General have the ability to take up cases on behalf of workers who have signed these agreements. And I'm wondering, either you may know of some. I think I just heard you mention one, but whether or not, how often that has happened, where there has been a worker who's come to the state having signed one of these agreements, and the state has taken up its role to be able to address their issues.
If I can beg the indulgence of being able to come back to the work session with.
Most certainly.
Because I certainly was attentive to these concerns when we were dealing with this last session. I don't know that I asked that question in that way to get that answer. So I want to make sure I provide you with accurate information. I will take that back and have that for the committee before work session.
Appreciate that. Thank you.
Thank you. Are there any other questions for the Attorney General this afternoon? Of course, we can always submit more questions to his office in writing between now and the work session if any come up after we hear some more testimony. Thank you for being here today.
Thank you, Senator. Thank you, Committee.
It does not seem like we have any other questions for you, so have a great weekend.
Thank you. You as well.
Next up to testify in opposition to this bill. Ms. Thompson, can you please make me the host again? I had to switch computers because my other computer was about to start a fire, it seems. Thank you. I appreciate that very much. And next up to testify is Mr. Bruce Garrity. And you may begin your video, sir. Thank you.
Senator Hickman, Representative Sylvester, who I know is remote, and members of the committee, my name is Bruce Garrity. I'm here on behalf of the Maine Automobile Dealers Association, which is the association of new car dealers throughout the state of Maine. And we are in opposition to LD 1711. We have a variety of concerns, a number of which have been provided in writing from different employer or employer groups. So I'll try to be brief. I know you've had a very long day. First, we believe that this legislation is based on the presumption that there are rampant problems. We don't believe there are. We certainly will concede that there are employers who act inappropriately and that those situations should be addressed. But we don't think the situation is so severe as it requires essentially privatizing actions that are normally within the purview of either the Department of Labor or the Attorney General's office. We believe, in fact, that this undermines both the process of the Human Rights Act, the Whistleblowers Act, and as I said, the actions taken by the Attorney General. Indeed, the way this legislation is drafted, the timeframes are too tight even for the Department of Labor to be able to participate. We think it will also add significant costs to the Department of Labor, the Attorney General's office, and costs associated with the court system. And I think cost is a key issue when you think about the background to this legislation, which is the California bill. I checked this morning. California alone has the 5th largest economy in the world and has just overtaken the economy of the United Kingdom. That is a very different background from what the state of Maine presents and respectfully what the state of Maine needs. We think this is an extremely complicated bill. I think that Senator Jackson mentioned that himself in his testimony, and we're concerned that so late in the session or the special session, this is being brought to the committee's attention. The last thing I would mention Senator, is that there have been references to frivolous claims, and I think Senator Jackson conceded that they existed, but he doesn't think they exist very often, and he thinks that the court system can address those. I would suggest that while attorney's fees is a significant component of this legislation, to the extent a court or an independent arbiter were to find a claim to be frivolous, that attorney's fees should run the other way and cost. And with that, Senator, I appreciate the opportunity to have spoken, and I'd be happy to try and answer any questions the committee might have.
Thank you, Mr. Garrity. Are there any questions from the committee for Mr. Garrity at this time? Sorry for the feedback.
Well, at least your computer isn't on fire.
This one isn't. Well, thank you for being here and providing your testimony, sir, and have a great weekend.
Thank you. You as well.
You're welcome. Next up, unless there's anyone here to testify in straight opposition to the bill that didn't sign up and would like to do so, please raise your hand at this time. Seeing no hands raised, I will invite to the panel Director Sneerson from the Maine Human Rights Commission to present her testimony, neither for nor against. Welcome.
Good afternoon, Senator Hickman and Representative Sylvester and distinguished members of the Committee on Labor and Housing. I will try to be brief. I'm Executive Director of the Maine Human Rights Commission, the quasi-independent state agency that enforces Maine's anti-discrimination law. We also are tasked under Title 26 with enforcing the existing Whistleblower Protection Act, which exists to protect employees from retaliation for reporting unsafe or unlawful activities to their employers. Our agency is 50 years old and historically underfunded. We have 6 investigators and 9 other staffers to process, investigate, and occasionally litigate between 600 and 800 complaints per year. Approximately 65 to 70% of those do relate to employment. Our process is a frustrating one and takes far too long for anyone's sensibilities to be satisfied. And that process, as frustrating it is, isn't even available to some people who are bound by mandatory arbitration. So that's all a backdrop by way of saying we agree with the goal of this by President Jackson to ensure that all employees are able to assert their statutory rights related to employment in a neutral, unbiased forum. We agree that employees should be able, they should have a remedy within state agencies, and they shouldn't be left without a remedy because state agencies like ours are under-resourced. So we think that the idea of the bill has tremendous promise. We love the idea that someone might recover monies and send them to us. In answer to one of the questions that has been asked a few times about one of the provisions in this bill to give, if a complaining party went to court, a private enforcement action and recovered monies, X amount would be designated to go to our agency. And the question is that routinely something that happens? Under the Maine Human Rights Act, our agency is actually prohibited from seeking damages or attorney's fees. And we are entitled to seek a civil penalty for punitive damage, but we don't seek that. If we ever are awarded it by a judge, we assign it to the complaining party. So I just wanted to answer that particular point. Our concern about this bill is really only about how it might impact our agency's ability to satisfy our statutory mandate to protect the public interest. Because we are under-resourced and because of the timing proposed in this bill, which I explain a little further in my written testimony, we are concerned that if a private enforcement action were started, we would not have an opportunity to finish even a preliminary investigation and start an enforcement action, which would be required in the 180 days before the private enforcement action. We were basically deprived of the opportunity to represent the public interest. And I do recognize that there is an opportunity within the statutory framework proposed here to allow our agency to opt into a private enforcement action. But realistically, we don't have the resources to track the pending actions and the notices and the amended notices and the checks and the filings, and to track what proposed remedies, whether The private parties settlements are in the public interest. For us, we just don't have the resources to keep track of whatever private enforcement action does happen. So our concerns are really pragmatic in how they affect our agency's ability to do its job. And with that, I'm happy to answer any questions.
Thank you, Director, for your testimony. And thank you for answering at least one of the questions that has come up. You are prohibited from seeking damages
And attorney's fees.
And attorney's fees by our own statute.
In the Maine Human Rights Act. Private parties, private litigants, if they proceed to litigation, they can recover attorney's fees or compensatory damages. Our agency cannot. At the same time, we also cannot be assessed attorney's fees. So it's a neutral stance.
Okay. And so in order for that provision of law to work with the current provision of law, there would need to be some amendment to make that happen. Is that correct to suggest?
I think that could be true. I have not studied that particular issue about whether the 1711 proposal, in order for a private enforcement action to seek attorney's fees, whether that would need to be amended. But that's actually a really great question.
Because it could be amended in a different direction, meaning that the Maine Human Rights Act could be amended to allow for you to receive the funds, even though you're not seeking them. I'm just.
Right. Yes, I think it's theoretically possible, yes.
And the second question that I had earlier that I hope you can answer is, under the current regime, if a person signs a forced arbitration agreement and there is discrimination or harassment by a protected class, on a protected class from an employer, would they still be able to file a complaint with your office and seek remedy in that way?
That does happen from time to time, that someone who is bound by a mandatory arbitration agreement files with us. And what typically happens is that the employer seeks dismissal because of the binding arbitration. And when that happens, our response is that our agency has jurisdiction to investigate. If the employer wants to bring a private action to force compliance with their employment agreement in another venue against their employee, they can do that, but we will continue. We have jurisdiction to investigate.
Okay, so you could currently investigate, say, sexual harassment on the job, even if that person has signed this private arbitration agreement as a condition of employment.
We could. The question about what would happen is if the employer did seek to enforce its employment contract and require the mandatory arbitration, the complainant could be forced to withdraw their complaint with us. And then the question would be, do we continue to have jurisdiction? So that issue could arise later.
Thank you. Chair recognizes Representative Warren.
Thank you for your testimony. I've got a question around something that the dynamic that you're mentioning. Do you feel that there is a need for more funds or someone, I guess, to be hired in this capacity? I don't want to put you on the spot, but even the things that you're mentioning around not being able to, I guess, receive certain funds, is that, would you know if that's completely out of the bounds ethically or something to amend the law in that way, to have that be a way to get greater funds to the Human Rights Commission? It seems that this is a legitimate issue and is maybe a bigger one than the context of this bill, but if that's the issue, it seems like one that could be solved, or that we should be considering in a solution, trying to find a solution. If you could speak to that, I don't want to put you on the spot, but.
You're not putting me on the spot, and I thank you for the question. The question of how to get additional resources to our agency is one that has bedeviled me for 10 years and my predecessor for 35. So we've given it a lot of thought. We did consider whether it was some agencies, other agencies in the state do have the capacity, if they proceed with litigation, not discrimination agencies, but if they proceed in a public interest action and receive settlement funds, to use that for their own, discretionary benefit or to improve the agency's performance. We explicitly considered whether to propose something like that for our agency, and we explicitly decided not to do that because we thought that it would give the appearance that our agency was engaging in litigation to raise funds. And we always want our actions to be seen as purely in the public interest to decrease discrimination and retaliation. So we have lots of other ideas, but that's not one of them that we're willing to pursue.
Representative Warren, you good? Thank you. Chair recognizes Representative Drinkwater.
Thank you, Mr. Chair. So what we're talking here today is about forced arbitration agreements. Do you have any statistics or data that could tell us how many of these do we see that are asked for you to intervene?
I don't have a statistic, but I would say a handful a year. But that also doesn't tell you how many employees have forced arbitration agreements.
True, but the ones that have reached out to actually, think they can file a complaint through you, you're saying a handful. So that would be 10 or less, I'm assuming.
I'm actually saying that a handful where the employer has contacted us seeking to have the case dismissed because they say it's prohibited by binding arbitration.
And what about employees trying to file a complaint with you for forced arbitrations?
We wouldn't know if there is a mandatory arbitration provision, generally speaking, unless the employer brings it up. So if an employee files a complaint with us, we get 500 employee complaints a year. We don't ask them, are you bound by, that's not a question that we ask. We just investigate the discrimination or retaliation complaint. So unless the employer brings it up essentially as a defense, we would have no way of knowing.
All right, thank you.
Thank you. Are there any other questions for the director this afternoon? Seeing none, as always, pleasure to see you. Thank you for being here today.
Thank you very much.
Is there anyone else in attendance who wishes to testify on this bill in favor, in opposition, or neither for nor against? Seeing no hands raised, I will close the public hearing on LD 1711. Thank you, committee, for your patience. We have one more stretch of the highway to go. It is 2:53. We need to end this meeting and find our emails and join the work session for the afternoon where we will take up LD 1022. But I will allow us, since we're already late for that, which is fine, it's the LegisZoom schedule, we'll take a 15-minute break so that people can find the link and get seated and get ready for a very interesting afternoon. See you in 15 minutes. Thank you all.